Fallout from the Supreme Court's decision to overturn Roe versus Wade continues here in Michigan. It means a 1931 law banning abortions could take effect. There's a preliminary injunction in place right now, putting that law on hold for the moment. But in Kent County, prosecutor Chris Becker says he is not bound by the preliminary injunction and could still enforce the law if a case met the elements of the 1931 ban. We've gotten a number of questions from viewers as well, asking to clear up some of the confusion stemming from last week's decision, much of it related to privacy concerns. We were asked how abortion-related prosecutions would work if your medical records are protected under the law. We asked 13 on Your Side's Charlie Tinker to verify.
Viewer Peg from Portage asked, why would HIPAA, a federal law, not keep anyone from knowing whether or not someone is having an abortion? Doesn't HIPAA protect a woman's right to privacy? To find out, we went to the text of Michigan's 1931 abortion statute, the online HIPAA guide, the Michigan Supreme Court, Levine & Levine attorney Anastasi Marcu, and the Kent County Prosecutor's Office. Let's verify. Though experts acknowledge there are some gray areas there that still need to be hammered out. Prosecutor Christopher Becker noted, quote, to dispel any confusion about the law, it does not allow for charges to be filed against the woman seeking or getting an abortion. It only allows for charges to be filed against a doctor performing an abortion. But what about privacy protections for those who do receive an abortion? As the question suggested, patient medical records are typically sealed under federal law, i.e. HIPAA, or state-level safeguards.
The reality is that every patient is HIPAA, the right to privacy.
If a patient's doctor, however, were charged with a crime, including under the 1931 law, experts acknowledge in most cases they're protected, but there is a chance relevant records may be admitted as evidence in court.
That particular question is not one that's easily addressed. Courts have to apply a test or a standard in Michigan about weighing the right to privacy, the right to confidentiality against the need for the record.
HIPAA guide notes whether providers have to comply with any subpoena or court order may also depend on who issued it, whether that's a judge, an attorney, or a court clerk. If valid, it would then be on the patient to fight the release of their records unless the provider decides to oppose the subpoena in writing. So we can verify, no, protections like HIPAA don't always apply, but that's evaluated on a case-by-case basis, though experts acknowledge trying abortion providers under the 1931 law has no modern precedent, meaning the first few cases could have an outsized influence on how they're tried moving forward. With your Verify, I'm Charlie Tinker.